Hey everyone, thank you for joining me for this audio podcast on copyright. My name is Christina Carde. I am the content manager for the ilovekickboxing.com studio in Winter Park, Florida, and today we'll be discussing the use of copyrighted materials, particularly for the ilovekickboxing.com Winter Park website. Now, if you're thinking, well, I don't need to know about copyright for I Love Kickboxing because that information doesn't apply to me, rest assured this information applies to pretty much any websites, personal or professional, that have plans to use someone else's work. So if you are interested in learning about the use of copyrighted material for your own website, please keep tuning in because I'm going to provide a lot of useful information in the next several minutes that will hopefully provide you with a good deal of insight into what you can and cannot do in regards to using copyrighted material. Okay, so a little backstory on kind of what led me to my decision to do this podcast. I was tasked with the job of basically revamping the design and content of the ilovekickboxing.com Winter Park Studio website. The website was having some issues, didn't have the best content, wasn't getting a lot of traffic, so the studio owner decided to just revamp the website and use some great effects, music, and other content to really grab site visitors when they first log on to keep them more engaged. Now, I would consider myself at least semi professional when it comes to good, compelling content because I do have a good deal of professional experience with that. But website designs are not my thing. Content I could do all day, designing websites, totally different story. So I did need to outsource for this service, but I Love Kickboxing Winter Park is a small fitness franchise studio, and unfortunately, I have a very limited budget to work with. So luckily, one of my instructors from my digital marketing master's degree recommended someone in the area of website design that was good and reasonable, and his name is Bruce Smith. I guess he had done some work for my instructor in the past, so he recommended him. So I contacted Bruce to get things moving with the new website design. What I quickly realized is that there was a lot of legal stuff that went into website design and content in the way of copyright, royalties, work ownership, etc., that I was not aware of, and it was clear that I was in way over my head. So I told Bruce, okay, let's just put a pause on things for a bit until I have time to do my research and make sure everything I'm doing is legal and within the boundaries of copyright law. So, there were four major issues that I discovered when doing my research on the use of copyrighted material. And I wanted to discuss these four issues specifically in this podcast because if you are experiencing any copyright issues with content or designs on your website, it's probably going to fall into one of these four boxes. The first is the use of someone else's music on your website. So, for the ilovekickboxing.com Winter Park website, one of the things that the owner wanted was a catchy, upbeat song as an intro when you first click on the website link. So, originally I thought, okay, I'll just download a song from iTunes, and as long as I pay for the song, I should be able to use it for whatever I want, right? Because I paid for it. That turned out to be the furthest thing from the truth. When I started doing my research on the use of someone else's music, and it's a good thing I did, or Drake may have come after us for using his song Do Not Disturb without permission. But I discovered that there were very specific laws that apply to the use of someone else's music. Basically, what the law says in regards to music copyright is that you are not allowed to use someone else's music for pretty much any reason without their consent. And this comes directly from the University of Minnesota's library article on the fair use doctrine. So if it's copyrighted by someone else, you can't just use it. Now, what is the fair use doctrine? Fair use is one of the main laws regarding exceptions to copyright law that provides a loophole of sorts to using an artist's work without their consent. So, fair use basically states there are some instances where you may be able to use someone else's work without their consent and without paying for it, but it needs to fall within very specific statutory parameters, and there is a lot of gray area there. According to fair use, in order for the doctrine to apply, the purpose and the character of the use needs to be considered. So essentially, what is it being used for? Why are you trying to use it? The second statutory factor is the nature of the original work, meaning is the original work actually published or not? Is it factual or creative, meaning is the work based on known fact, like a documentary? And copyright doesn't protect facts, so it would need to be creative, like a song or an art piece, which is protected by copyright. So those are the first two factors that apply in the fair use doctrine. The other two statutory factors to consider are the amount and substantiality of the portion used. So, in other words, are you using the entire song or just part of the song? What part of the song? And then there's the effect of the use of the potential market for or value of the source work, which is a really long way of saying, is your use of this work on your site going to make the work more profitable in its particular market in the future? So basically, if I use a Drake song on my company's website, is that going to make that song more popular in the music market in the future? Is it going to make people pay for the song, download it, etc.? If so, a court may be a little bit more obliged to side with my use of the work. So unless you're a copyright attorney, which I am not, and know specifically whether or not the fair use doctrine applies in your situation, the University of Minnesota basically recommends to just not take that chance and not use the artist's work at all unless you know something about copyright or are in the position to hire a copyright attorney. And I know for a fact the budget I was given doesn't accommodate that. Now, does that mean you can never use music on your website? No, obviously it doesn't, or no website or YouTube channel or anything would ever have music, and life would be boring. However, there are some specific sites that you can go to that have royalty-free music that you can download and use, and you don't have to worry about anyone coming after you or your company. A really great video that talks about this is a video by David Walsh, Walsh. He is a YouTube copyright and video expert professional, and he lists specific sites that you can go to download or use royalty-free music without penalty. So I'm not going to list all the sites here because there's too many to list, but two of the more popular sites are youtube.com's no copyright sound channel, and SoundCloud also has a royalty-free option as well to download music. Now, you will have to put the link to the music source on your site, so you do have to cite it correctly, and you may need to use a disclaimer, like I do not own the rights to this music, but at least you know that the song is royalty-free, and you won't get in any legal trouble. So that's the first issue. Easy answer to that: use royalty-free sites for music. It will save a lot of time and headache. The second issue I came across is the use of a piece of artwork on your website. When talking to Bruce about the website design for I Love Kickboxing Winter Park, he actually suggested using a popular piece of artwork on one of our site pages, and we ended up narrowing it down to two popular art pieces, one by Leonardo da Vinci and one by Andy Warhol. So just like with the use of music, I decided to research the use of popular pieces of art, and I came across a law that deals with public domain. So according to copyrightuser.org, any artist's work that is copyrighted is protected from public use. So the same rules concerning explicit consent to use the work apply until the copyright expires, which is 70 years after the artist's death. So basically, once an artist has been dead for at least 70 years, their work becomes public domain, meaning anyone can use it for pretty much any reason without penalty. Now, other factors to consider. Was there more than one author or creator, and if so, are they both dead? When did the last author or creator die? Just because one author died 70 years ago, the other one may have died years after that. So in that case, the work may not still be protected, so you have to check. Also, are you using the original work or an adaptation or translation? For instance, the original text of the Bible or the King James Version is public domain because the author and translator of this work has been dead for way more than 70 years now. But let's say someone came out with a brand new translation of the Bible 10 years ago. Well, that's a new adaptation and could still be subject to copyright. So the two questions that are important to ask when trying to figure out if a work is public domain or not: who created the work and when did they die? In the case of the piece of artwork for my company's site, it would probably be best to go with Da Vinci's work because we know for a fact that he was the creator and he has been dead for more than 70 years. Andy Warhol has been dead for less than 35 years, so using his artwork would probably be a little bit more challenging. The third issue you may come into contact with when trying to design a website, particularly if you hire an independent contractor to do your design, is does that designer own the work he did on your site? So based on the research that I did, the short answer is no. According to attorney at law Lloyd Jasson, who published an article concerning trademarks and intellectual property on copylaw.com, there is something called the work for hire doctrine that deals specifically with this matter. So to illustrate the work for hire doctrine, we'll use Bruce, the website designer I employed to design I Love Kickboxing Winter Park new website. Based on the work for hire doctrine, when it comes to freelancers or independent contractors, which is what Bruce essentially is, three factors must exist. So three conditions must exist in order for Bruce to be able to claim work for hire under the Copyright Act. First, it must be original work of his that has never been created before for anyone else. So if he was designing like a specific graphic for the website that had never been designed before by anyone else, or that he had never designed for anyone else, then he may be able to copyright that work and claim it as his. Just like if an artist displays their original work in an art gallery, the gallery doesn't own that work, they're just charging the artist to display it. Now, in the case of what Bruce is doing for our company website, there's nothing original that's being done by him. The design is through an already established website design generator, the content is from other sources, so this wouldn't be an issue for our company per se. The second condition that must exist for Bruce to claim work for hire status is both he and I would have to sign a work agreement stating that his work was work for hire. Absent that contract, Bruce cannot claim rights to any work he does for hire. There is no such contract between I Love Kickboxing and Bruce, so we're good there. So if there is no contract saying that this is a work for hire job, then the contractor or freelancer cannot claim work for hire. Lastly, the nature of the work for hire must fall within one of the following 9 categories. So it must either be a translation, a contribution to a motion picture or audiovisual work, a contribution to a collective work like a magazine, an atlas, a compilation. It must be as an instructional text, as a test, as an answer for material on a test, or as a supplementary work like a forward, a chart, an illustration, like I just mentioned, like an original graphic, something like that. So one of those 9 categories has to be in play in order for this to be considered a work for hire situation. So in order for work to hire apply, all 3 of these conditions must be present, not just one of them. In the case of the work Bruce is doing for the I Love Kickboxing website, these conditions don't apply, so Bruce does not have a work for hire claim should he seek one. Okay, so the last copyright issue that would more than likely come up where a website is concerned is whether or not copyright applies if either no one or a limited amount of people are going to be viewing the site where the copyright material is contained. So let's say I Love Kickboxing was a mythical company, which it's not, by the way. In fact, if you live in the Winter Park area and are into fitness, you should totally check them out because their workouts are next level. But anyway, let's say for the sake of argument, it's a mythical company generated for the purpose of my master's degree program, and the website I created on it is for my school assignments only, and only my instructor is going to be viewing what I submit. Does copyright still apply then? Based on all the research I've done and all the sources I've listed thus far, the short answer is possibly, but more than likely yes. When applying the fair use doctrine, it is possible that the minimal use of some copyrighted work for education purposes may be considered okay. However, again, fair use has a lot of gray area and is not specific as to what extent copyrighted work can be used for education purposes without causing an issue. Secondly, now someone other than myself has possession of my work. What if my instructor decides the copyrighted material is something that he really likes and something he wants to share? Let's say he shares it on social media with the copyrighted material on there. Say it magically goes viral. Now we're both in a position to be in violation of copyright law because we never had permission to use or share the copyrighted material to begin with. So short answer, yes, more than likely this could cause a problem, and copyright does still apply unless you're really trying to use the fair use doctrine. So short answer to all of this in a nutshell, if it's copyrighted, just don't use it unless you know the person who created it personally and can get their permission. It's a lot easier, cheaper, and faster to use the royalty-free or public domain works, and it will save you a lot of time, money, and heartache in the long run. Thank you for tuning in for this podcast. I really hope it gave you the information you need for your future website endeavors when it comes to copyright law.